Ava Gomez claims a family friend asked her to watch her 2 kids while she was on vacation, but wasn't paid as agreed. Lisa Ma says Ms. Gomez went on a spending spree with her credit card, so she owes her nothing.
I see Ms. Ava Gomez here as my plaintiff, Lisa Ma as the defendant. Ms. Gomez, you are suing for $500, alleging that the defendant owes you money for unpaid child care. Tell us why we're in court today.
Your Honor, I'm here today because I am suing Lisa for not paying me for babysitting her children. Lisa offered to pay me $500 to babysit her children, and I typically watch her children for free. And that's only for a day or 2.
Right.
And this time it's for a week. While she's on vacation in Maui with a man that she's only been dating for a few months.
Okay, that's not your business, Ms. Gomez. She's on vacation for a week. While normally you do this for free because it's a day or 2, obviously she's going to pay you because it's a week-long supervision of her children.
Exactly, Your
And
Honor.
how many children and what are their ages?
She has 2 children. They are 8 and 9 years old.
Okay. And you say great, $500 was a good fee?
Yes.
Okay.
So I said yes to that. Per usual, she offered me her credit card, and she never gave me any limit to it. So her children were on spring break, and I wanted them to have fun. So I took them out to the movies, restaurants, and then a water park. They had a great time.
Your Honor, can I clarify something?
I'm going to give you this opportunity one time, Ms. Ma. What do you need to clarify?
Thank you. When I pass Ava my card because I trust her without giving her any restrictions. Previously, she also have my credit card and she never spent more than $30 a day. And this time she charged it $620 over 7 days. And when I passed her the card, I did tell her that you can spend it on whatever my kids need.
You said kids need.
Yes, and before I go on to my trip, I stock up my 2 large refrigerators. I went to 3 grocery stores, bought all the frozen food, fruits and veggie, plus some quick and easy meal for Ava, because I know she loves to cook pasta. So I really make sure I have everything ready. I even checked with her. She said, yeah, that's good enough. So this time I was really confused and frustrated that she's charged my card $620 without even asking for permission. Previously, she's always so polite. Even last time, she charged it like $30 for Chinese takeout.
Right.
She sent me a text and kindly asked me, oh, can I spend on this? I was like, go ahead.
Yeah, but you didn't get any text while you were in Maui with your new man.
The only text I got was a picture of her, took my 2 daughters out for a movie.
Having fun, right, but you didn't get any financial updates.
No.
So you were quite surprised when you got your credit card bill.
I was very shocked and confused in the beginning.
Yeah.
And when I confronted her, she was like, oh, I didn't want to bother you when you're on your vacation.
Your Honor, may I interrupt?
No, I don't want any more interruptions from either of you. What I would like is for both of you to give my bailiff any evidence. Y'all are talking about receipts and credit card bills. Please offer your evidence to my bailiff. Thank you.
Thank you.
Plaintiff's on the top.
Thank you, sir. Okay, so let's see, Ms. Gomez, you are providing a text message. Hey, could you watch the kids when they're on break? I'll give you $500 this time for helping me out, acknowledging that this is the first time you've actually paid her cash to watch the children. You say, sounds great, I'm in. Okay, so that's undisputed. Let's see what Ms. Ma is offering up. Yes, this is what I expected, a credit card bill. This is exorbitant. I can tell the court right now, seafood, $56, movie theater, $50. Water park, $50. The steak place, $50. You said these kids are 8 and what?
9 years old, and they don't eat steak.
No,
Your Honor.
Apparently they do, Miss Ma. Okay, so you said, breaking news. Yeah, they can tear up a ribeye. Okay, so you said 9 and how old?
8 and 9
8 and 9, okay. House of Wok, I guess some type of Chinese. More movie. How many movies did y'all see? It looks like y'all went to the movies every day. Y'all went to the movies 4 times?
We did, yes.
And I have Netflix at home.
Okay, hold on. Hold on, Miss Ma. Okay, Joe's Cantina, Bill's Burger. Ma'am, so you were really spending on average $100 a day.
Yes, I was. But Your Honor, again, she was on vacation. I did update her with pictures of where we were at.
So
Three
they had the time of their lives. But your point is it was on your expense that you did not authorize. Is that your issue?
Correct. She didn't ask for my permission. I never asked her to do that. And my two girls are very low maintenance. One
No,
girl,
ma'am, not anymore.
Yeah.
No, ma'am, not anymore.
Coming up on Equal Justice.
It is a lot of money, Ms. Gomez, and you can beat around the bush and say that you had full authorization, but the court is not convinced because that is an exorbitant amount of money for two children.
And later,
What do you say, young man, to her accusation that you and your frat buddies are constantly throwing loud, obscene parties and disturbing the peace?
I don't see anything wrong with a little bit of party.
Equal Justice is back with the case of Ava Gomez, who brought Lisa Ma to court for cheating her out of babysitting fees.
Do you think this was exorbitant spending?
I didn't think so.
So reconcile for me why every occasion you watched this woman's children before this week, it was $30 here, $30 there, with permission that you received on the front end, and then we went from no authorization, no permission, to $620.
Well, she gave me her credit card. She didn't give me a specific amount of how much I could spend.
No, but you're 20 years old, right?
I am, yes.
And you're a nursing student.
Yes.
So that means I'm to assume that you have reasonable skills of deduction and understanding.
Yes.
Okay, so you understand there is something between $30 and $620.
Yes, Your Honor.
You see there's a gap there in terms of expectation financially?
Yes.
So if you're used to my babysitter spends about $30 here or there to $620, you understand why this woman is surprised.
Mm-hmm.
It is a lot of money, Ms. Gomez, and you can beat around the bush and say that you had full authorization, but the court is not convinced because that is an exorbitant amount of money for two children. And I really do need you to contend with that. Ms. Ma, but what about the argument that if you cared so much what was being spent, why didn't you leave a limit?
because I really trust her based on her previous behavior. And I've known her for so many years. I watched her growing up.
So this was shocking to you. When you got this bill,
Very shocking, and I honestly feel it's like a violation of trust.
Did you call her upset or text her? How did you communicate
She
your
was there.
upsetness?
Yes, great question. She was there. I confronted her. Okay, thanks for taking care of my daughter. I'm not gonna pay you additional $500.
So you told her that to her face?
I told her to the face.
And what did you think about that?
I was upset because I'm spending my week watching her children, and I am in nursing school, and the amount of studying I have to do, I had to put aside to watch her children.
What did you think would be reasonable? When you did pull up your credit card statement for the month, you did know that there would be some charges associated with the week that she cared for your two girls, right? What did you expect that number to be?
Below $300. She used to spend less than $30 a day. I understand it's spring break, they may want to go for a movie. But my daughters never asked to go for a water park or a
Right.
steakhouse. All these are new for them. That's why they're so excited. And
I agree with you.
I'm concerned. I'm a mother of two. It's hard to raise two daughters by myself.
Oh, you're
I
by
didn't
yourself,
want-
single mom.
Yes, I'm single mom.
Yeah.
I don't want to spoil them in this way.
Right. No, I agree. I've heard enough, ladies. I am ready to rule. So I've already told you, Ms. Gomez, that listen, I think you're a fine young lady. I appreciate that you are getting your education, particularly in nursing. It's an excellent field. You should be well paid when you get out of it. Speaking of payment, you're not going to get $500 from this court today, and I'm going to tell you why. While I can appreciate that you were not given a specific articulated limit on Ms. Ma's credit card to spend for this week of caring for her children, there is such thing as pattern, usage, and behavior, okay? And you had already established a spending pattern with this woman. This is supposed to be a loving, trusting, reciprocal relationship. And you violated that love and trust, Ms. Gomez, by running this woman's credit card bill up $600-some. You have a reasonable duty of cautious care and exercise with her credit card as you would be using it with your own money. And I'm not really convinced that you would spend $620 for 1 week on 2 children. And if you were to do that, the court would find that foolish. I'm just going to be direct with you. Now, that said, there was some things you could have done to tighten in the spending ropes there, Ms. Ma. You could have said, here's a card. She is 20. She's 20. She's still very, very much coming of her development when it comes to finances, spending, and adult decision making. Okay? So next time, despite the practices and patterns established, you might want to go ahead and be overly cautious, Miss Ma, and say, and this is the limit. And if you don't feel comfortable sharing it to her, call your credit card company. Tell them, once this gets over $600 for the next, or $300 rather over the next week, flag on the play, freeze the card, fraud alert, anything that we can do in this technological age that we live in that can make sure that our spending and money is safe. So this is what I'm going to do. I am going to take your good faith word, Miss Ma, that you expected to spend around $300, no more. I'm going to deduct that from the $500 that you originally owed the plaintiff just for her babysitting services, and I'm going to rule in favor of the plaintiff for the amount of $200. That is my ruling.
All rise.
Judge Eboni has ruled in favor of the plaintiff. The defendant is ordered to pay $200.
Maybe you should keep your word next time and prioritize your children over a man.
I really hope that one day you realize maintaining a trust is more worthy than the money.
Coming up on Equal Justice.
So he didn't offer to help repair the damage or anything?
He did not.
Is that true, Mr. Michaels?
That is true. It's true that I told her to move her car and she just didn't take the opportunity to do it.
This is Equal Justice. Lori Smith claims her car was damaged after her neighbor took his rowdy parties too far. Austin Michaels says he spoke to all of his neighbors in advance so they could move their cars, but the plaintiff ignored him.
Ms. Smith, I see you're suing for $1,500. Tell us why we're in court today.
So, Your Honor, we are in court today because I am suing my completely disrespectful neighbor, Austin, because he has these unruly parties with his little frat boys, and they had this big destructive party out in their front yard, throwing these balloons filled with foam, which destroyed one side of my car.
Okay, and do you have any proof to the court, ma'am, as to the damages you're asking for?
I absolutely do.
Please proffer that up to my bailiff, ma'am. You can give him everything.
Sure.
Great, thank you. Let's take a look at this alleged damage here. Thank you, sir. Oh, my. Okay, let's see what we're all looking at here on the plasma. This is your SUV motor vehicle, ma'am, and I see exactly what you mean.
Yes.
This is a real eyesore here with this frosty kind of white residue.
It was some type of foam that got smashed, and I actually believe that it was deliberate.
So, I see where you did take it to a professional body shop here, and you did pay for $900 for the paint itself, and then the labor was another $600, totaling $1,500.
Yes.
Okay, let's get to you, Mr. Michaels. What do you say, young man, to her accusation that you and your frat buddies are constantly throwing loud, obscene parties and disturbing the peace?
I don't see anything wrong with a little bit of party once in a while, you know?
Coming up on Equal Justice.
What'd you say about that, Mr. Michaels?
I think since she's really the only neighbor that didn't move her car, there's probably something wrong with her.
This is Equal Justice. Equal Justice is back with the case of Lori Smith, who blames her neighbor, Austin Michaels, for her car's ruined paint job.
So let's get to this particular party, Mr. Michaels. So you let her know, hey, I'm going to have some buddies over and we're going to have a party. And did she know there were going to be these balloons with foam or all this stuff in it?
So I walked around my neighborhood the day before the party with a flyer. I actually have it right here.
Oh, great. Go ahead and proffer that to my bailiff, sir. Let me take a look. Okay, thank you. Oh, Lord. Okay, hey, neighbors, just wanted to inform you that we will be throwing a birthday party on January 21st. It will involve throwing balloons filled with foam around the front yard around 2 p.m.
Yep.
We suggest that you move your car before that time. Thanks, and enjoy the freshly baked cookies from the store. Okay, so this was available to all the neighbors?
Yeah, I brought it to every single neighbor and I talked to them firsthand, and every other neighbor moved their car except for...
But you did speak to her?
I did speak to her, yes.
Okay, ma'am, did he?
He asked, he gave me that flyer, yes.
And did you tell him at that point, I don't think so?
Yeah, I did.
Yeah.
I told him, I'm not moving my car. Why should I be inconvenienced for you to have a party? Keep it in your yard.
Yeah. What'd you say about that, Mr. Michaels?
I think since she's really the only neighbor that didn't move her car, there's probably something wrong with her.
Mr. Michaels, you do admit, though, that this destruction to her car is a result of you and your homeboys throwing these water balloons?
Yes, but if I would have seen it on the car, then I would have washed it off.
Did you tell him at some point that your car was ruined?
So I did, but he was very callous about it.
Ooh.
Like, well, I told you should have moved your car.
So he didn't offer to help repair the damage or anything?
He did not.
Is that true, Mr. Michaels?
That is true. It's true that I told her to move her car and she just didn't take the opportunity to do it.
Okay, so she didn't do that. So you think she deserved what she got, Mr. Michaels?
It's kind of her fault, I think.
Judge Ebony's verdict when Equal Justice returns. This is Equal Justice.
I understand, Mr. Michaels, that you are at the stage of life where it's all about fun and good times. But the other part of it is this. When you grow up and you pay these things called mortgages and car payments, insurance, bills, taxes, you do have a right to what we call quiet enjoyment of your property. And while everybody else has accommodated you, Mr. Michaels, she has no legal duty to do that. So while I can appreciate this little notice in the cookies, you had it right when you said suggest. You said, I suggest you move your car, because you are in no legal position, young man, to have legal authority to mandate or demand anything from this woman or anybody else in your neighborhood. Therefore, you were out of order. She had no responsibility or duty to you to move said car just because you asked with cookies. Therefore, the court will rule in complete favor of the plaintiff to the tune of $1,500. That's my ruling.
Judge Ebony has ruled in favor of the plaintiff. The defendant is ordered to pay $1,000.
The heavy oak doors of the courtroom creaked open, revealing a space where the air seemed thick with the weight of responsibility and the pursuit of truth. At the front of the room, a polished nameplate sat firmly on the bench, catching the soft glow of the overhead lights. It bore the name of Judge Eboni K. Williams. To those who entered this sanctuary of the law, that name represented more than just a title. It was a promise of a unique perspective, a blend of different worlds brought together to serve the cause of fairness. Judge Eboni looked out at the gallery with a gaze that was both sharp and deeply empathetic. She often told those who stood before her that the only thing that truly mattered in this particular courtroom was how she perceived the facts and the hearts of the people involved. Her identity was a tapestry woven from various corners of the nation. She carried the warm, grounded roots of North Carolina and the soulful resilience of Louisiana. To this foundation, she added a layer of West Coast cool and the unmistakable, sharp edge of New York City. This combination allowed her to see through excuses and get straight to the heart of human conflict. On this particular morning, the atmosphere was charged with the quiet tension of unresolved grievances. Judge Eboni scanned the room, her eyes settling on a woman who seemed restless. She asked with a calm but firm tone if there was a problem. The woman quickly replied in the negative, addressing the judge with the respect her honor deserved. For Judge Eboni, equal justice was not just a legal concept found in dusty textbooks. It was the manifestation of the most important values of the country, freedom and integrity. These were the stars she navigated by every single day. She understood that while a woman might run her own household with absolute authority, every individual deserved the same right to govern their own life and space. Judge Eboni had chosen to become an attorney and pursue the law because she possessed a burning desire to be a voice for those who felt unheard. She knew that the court was a place where people from all sectors of life intersected. Whether they were black, white, purple, gay, straight, or queer, they all came seeking the same thing, a fair hearing. This was the essence of the work conducted by Judge Eboni K. Williams. The first case of the day involved two women whose long-standing friendship had been strained by a disagreement over money and trust. Ava Gomez, a young and ambitious nursing student, stood as the plaintiff. Opposite her was Lisa Ma, a hardworking single mother who served as the defendant. The dispute centered on a $500 babysitting fee that Ava claimed was owed to her, while Lisa argued that the debt had been canceled out by unauthorized spending. Judge Eboni looked at Ava Gomez and asked her to explain why they were in court. Ava began her story, her voice steady but tinged with a hint of frustration. She explained that she had been a family friend for a long time and typically watched Lisa's children for free when it was only for a day or two. However, this situation was different. Lisa had planned a week-long vacation to Maui with a man she had only been dating for a few months. Because the commitment was much larger this time, Lisa had offered to pay Ava $500 to supervise her two children, who were 8 and 9 years old. Judge Eboni acknowledged that $500 seemed like a reasonable fee for a full week of childcare. Ava agreed, noting that she had accepted the offer. During the week of spring break, Lisa had provided Ava with her credit card to cover any necessary expenses for the children. Ava testified that Lisa had never given her a specific spending limit. Wanting the children to have a memorable and fun break, Ava took them to the movies, various restaurants, and even a water park. She believed she was doing a wonderful thing for the kids. Lisa Ma, however, had a very different perspective. When given the chance to speak, she expressed her deep confusion and frustration. She explained that she had trusted Ava implicitly because she had known her since she was a child. In the past, when Ava used the credit card, she never spent more than $30 a day and would always send a polite text message asking for permission first. This time, while Lisa was away, the charges totaled $620 over 7 days. Lisa described how she had carefully prepared for her absence. She had stocked 2 large refrigerators with frozen food, fruits, and vegetables, even making sure there was plenty of pasta because she knew Ava loved to cook it. She had checked with Ava before leaving, and Ava had confirmed that the supplies were sufficient. Lisa felt blindsided when she returned to find a credit card bill filled with charges for seafood dinners, steakhouses, and multiple trips to the movie theater. Judge Eboni called for the evidence to be presented. She reviewed the text messages and the credit card statements provided by the bailiff. The bill showed a $56 charge for seafood, $50 at a movie theater, another $50 for the water park, and $50 at a steak place. Lisa pointed out that her children were only 8 and 9 years old and did not typically eat steak. Ava countered that they actually enjoyed it very much. The records showed they had gone to the movies 4 separate times in 1 week, despite having access to streaming services at home. Judge Eboni observed that Ava had been spending an average of nearly $100 a day. While Ava argued that she was simply giving the children the time of their lives, Lisa felt it was an unauthorized expense that violated their mutual trust. Lisa explained that as a single mother, she worked hard to provide for her daughters and did not believe in spoiling them with such extravagant outings. The judge turned her attention back to Ava. She noted that Ava was 20 years old and a student in the demanding field of nursing. This implied that Ava possessed the skills of deduction and understanding. Judge Eboni pointed out the significant gap between the previous spending pattern of $30 and the new total of $620. She explained that even without a written limit, there is a reasonable duty of cautious care when using someone else's money. By running up such a high bill, Ava had violated the trust that was the foundation of their relationship. However, Judge Eboni also offered a gentle critique to Lisa. She advised that in the future, especially when dealing with a young adult who is still developing their financial decision-making skills, it is always best to set a clear and articulated limit. In the modern age, one could even use technology to set alerts or freezes on a card to ensure safety. In the spirit of fairness and finding a middle ground, Judge Eboni delivered her ruling. She decided to take Lisa at her word that an expenditure of $300 would have been acceptable. Therefore, she deducted that $300 of excess spending from the $500 originally owed for the babysitting services. She ruled in favor of Ava Gomez for the remaining amount of $200. As the parties left, Judge Eboni hoped they would both learn the value of clear communication and the importance of maintaining trust over material gain. After a brief recess, the court reconvened for the second case. Lori Smith, a composed woman who took great pride in her property, was suing her neighbor, Austin Michaels, for $1,500. Lori claimed that her sport utility vehicle had been damaged during one of the rowdy parties hosted by Austin and his friends. Lori described the scene to the court with a sense of indignation. She explained that Austin and his fraternity brothers frequently held loud and unruly gatherings. During one particular event held in the front yard, they had been throwing balloons filled with a white, foamy substance. Some of these balloons had struck her vehicle, leaving a frosty residue that ruined the paint job on one side of the car. She presented a professional estimate showing that the repair required $900 for the paint and $600 for labor. Austin Michaels, a young man who seemed to prioritize fun above all else, defended himself by claiming he had been a responsible neighbor. He explained that he had gone around the neighborhood the day before the party to hand out flyers. He even brought freshly baked cookies from the store to sweeten the news. The flyer informed the neighbors that there would be a birthday party involving foam balloons in the front yard at 2 in the afternoon and suggested that they move their vehicles to avoid any issues. Austin testified that every other neighbor had complied with the suggestion except for Lori. He admitted that the damage to her car was a direct result of the foam balloons, but felt that Lori was at fault for refusing to move her car when she had been warned. He even suggested that something must be wrong with her for being the only one to stay put. Judge Eboni listened intently, her expression becoming more serious. She asked Austin if he believed Lori deserved the damage because she had not followed his suggestion. Austin sheepishly replied that he thought it was her fault. When it came time to rule, Judge Eboni addressed Austin with the wisdom of someone who understood the transition from youth to adulthood. She explained that while she understood his desire for fun, being an adult involved respecting the rights of others. She clarified a vital legal principle, the right to the quiet enjoyment of one's property. The judge pointed out that while Austin had used the word suggest in his flyer, he had no legal authority to mandate or demand that his neighbors move their cars. Lori had no legal duty or responsibility to move her vehicle just because he wanted to throw balloons in his yard. By causing damage to her property while engaged in his activities, Austin was legally liable for the repairs. Judge Eboni ruled in complete favor of Lori Smith for the full amount of $1,500. She looked at Austin and expressed her hope that this experience would help him grow up and understand that his freedom ends where the rights of others begin. To Lori, she offered a smile, acknowledging that she too knew how to have fun, but always within the bounds of respect for her community. As the courtroom cleared, the echoes of the day's lessons remained. Whether it was a dispute over a babysitting fee or a ruined paint job, the underlying themes were the same: the importance of integrity, the necessity of clear boundaries, and the unwavering pursuit of equal justice. Judge Eboni K. Williams had once again served as the steady hand of the law, ensuring that every voice was heard and that every decision was rooted in the fundamental values of the country. The participants walked away, perhaps a bit wiser, carrying with them the realizations that only a fair and compassionate court could provide. The pursuit of justice, as Judge Eboni knew well, was a journey that required both a sharp mind and a kind heart. The courtroom was a space defined by more than just mahogany wood and the heavy silence of protocol. It was a theater of human reality where the abstract concept of the law met the tangible complexities of daily life. At the center of this world sat the nameplate that commanded attention and respect: Judge Eboni K. Williams. To those who entered her sanctuary of justice, she was not just a figure of authority, but a lighthouse of clarity. She often told those who stood before her that the only thing that truly mattered in this particular courtroom was how she perceived the truth. Her perspective was forged in the fires of a diverse journey, coming from North Carolina by way of Louisiana, carrying with her a certain West Coast cool balanced perfectly by a sharp New York edge. She was a woman who sought to understand the heartbeat of the people as much as the letter of the law. On this particular day, the air in the room was thick with the quiet tension of unresolved disputes. Judge Williams looked down from her bench, her gaze steady and searching. She asked if there was a problem, to which the response was a respectful negative. For her, equal justice was the cornerstone of the most important values of the country: freedom and integrity. These were the ideals she strived for every time she donned her robe. She understood that in the grand tapestry of society, every individual ran their own household and that autonomy was sacred. She had decided to become an attorney and pursue the law because she wanted to be a voice for the voiceless, a protector for those who felt overwhelmed by the world. The first case of the day brought two women forward, their faces etched with the weariness of a friendship turned sour by financial misunderstanding. Eva Gomez, the plaintiff, stood on one side, while Lisa Ma, the defendant, stood on the other. The dispute was over $500, a sum that represented a week of childcare provided during a spring break vacation. Judge Williams began the proceedings by inviting Miss Gomez to speak. The young woman, a 20-year-old nursing student, explained that she was suing Lisa for failing to pay the $500 they had agreed upon for babysitting services. Normally, Eva would watch the children for a day or two without charge as they were family friends. However, this time was different. Lisa was going on a week-long vacation to Maui with a man she had only been dating for a few months. Because the commitment involved a full week of supervision for two children, aged 8 and 9 years old, a payment of $500 had been settled via text message. Miss Gomez argued that during the week, she wanted the children to have an enjoyable spring break. Since Lisa had provided her credit card without explicit restrictions, Eva took them to the movies, restaurants, and a water park. She claimed the children had the time of their lives. However, the atmosphere shifted when Lisa Ma was given the opportunity to clarify her position. With a voice trembling with frustration, Lisa explained that while she trusted Eva, the spending had been exorbitant. In the past, Eva had used the card for small expenses, never exceeding $30 a day. This time, the bill had ballooned to $620 over 7 days. Lisa had stocked her 2 large refrigerators with fruits, vegetables, and easy meals before she left, yet Eva had charged seafood, steak dinners, and multiple movie trips to the card. Judge Williams examined the evidence provided to her bailiff. The text messages confirmed the $500 agreement, but the credit card bill told a different story. The judge noted charges for a seafood restaurant totaling $56, a movie theater for $50, a water park for $50, and a steakhouse for $50. She questioned how children aged 8 and 9 could consume so much, especially when Lisa argued they were low maintenance and had never asked for such luxuries before. The judge looked at Miss Gomez and noted that as a nursing student, she should possess reasonable skills of deduction. There was a significant gap between the expected $30 a day and the ultimate $620 total. The judge pointed out that running up a bill of that magnitude for 2 children in a single week was not only surprising, but also a violation of the trust that formed the foundation of their relationship. Turning to Lisa, the judge also offered a lesson in prudence. She suggested that in the future, regardless of established patterns, it was wise to set specific limits or use technological tools like fraud alerts to safeguard finances. However, the court found that Eva had a duty of cautious care which she had failed to exercise. The ruling was delivered with the weight of fairness. Judge Williams acknowledged Lisa's expectation of spending no more than $300. She decided to deduct that $300 from the $500 originally owed for the babysitting services. Therefore, the court ruled in favor of the plaintiff for the amount of $200. As the parties were dismissed, the judge hoped that the lesson of maintaining trust would eventually outweigh the bitterness over money. As the first pair departed, a new conflict emerged, representing a clash between the exuberance of youth and the rights of a homeowner. Lori Smith, a woman who valued the peace of her neighborhood, brought a suit against her neighbor, Austin Michaels, for $1,500. Miss Smith presented her case with a sense of deep disrespect. She described how Austin and his fraternity brothers held unruly parties in their front yard. During one such event, they threw balloons filled with foam, which resulted in significant damage to the side of her sport utility vehicle. She provided documentation from a professional body shop showing $900 for paint work and $600 for labor, totaling $1,500. Austin Michaels, a young man who seemed to view life as one continuous celebration, defended himself by stating he had provided notice to the neighborhood. He had distributed flyers accompanied by store-bought cookies, informing neighbors of the party and suggesting they move their vehicles. He argued that because Miss Smith was the only neighbor who refused to move her car, the responsibility lay with her. Judge Williams scrutinized the flyer. It was a polite enough gesture, mentioning the foam balloons and the 2 post-meridium start time. However, the judge challenged Austin on his understanding of the law. She explained that while he had suggested people move their cars, he lacked any legal authority to mandate such an action. The judge spoke to the heart of the matter, the right to quiet enjoyment of one's property. She reminded the young man that when one grows up and takes on the responsibilities of mortgages, insurance, and taxes, that right becomes paramount. Miss Smith had no legal duty to move her vehicle simply because her neighbor wanted to throw foam balloons in a common area. Austin's callous attitude toward the damage, suggesting that Miss Smith deserved what she got for being an inconvenience, did not sit well with the court. Judge Williams ruled that Austin was out of order. She held him fully responsible for the destruction caused by his actions. The court ruled in complete favor of the plaintiff for the full amount of $1,500. As the proceedings concluded, Judge Williams watched the participants leave. She had navigated through the complexities of friendship, the boundaries of financial trust, and the essential rights of neighbors. In her courtroom, equal justice was not just a phrase, but a living practice of balancing the scales, one human story at a time. The echoes of her final words lingered in the room, a reminder that while the law provides the rules, it is integrity and respect that provide the harmony for a functioning society.